make sure that, you know, for everyone's, so everyone can hear that we've muted. So I'll start over. Thank you for joining us for today's webinar. My name is Angelique Jackson. I'm the Manager of Business Development and Marketing here at Charles E. Smith Life Communities. And to just tell you a little bit about us, we are a Jewish faith-based nonprofit organization located in the heart of Rockville, Maryland. And for over a century, we have been serving older adults in our community. We offer the full continuum of care here, from independent living, both at Ring House and Revitz House, our assisted living at Landau House, memory care at Cohen Rosen House, and post-acute and long-term care at Hebrew Home of Greater Washington. I'd like to take some time to introduce our sales team. Unfortunately, Hannah is not with us, but John Quinn is here today, and I'll let him say hello.
Good morning, everyone. My name is John Quinn. I'm a sales counselor here at Ring House. I also represent Landau House, which is assisted living, Cohen Rosen memory care, and here at Ring, we're independent living as well. So here's my shameless pitch. At the end of the seminar, if you would like, I would love to give you a tour of our community. If you have a pen, my phone number here is 301-816-5050. Number again, 301-816-5050. And I'm going to turn it over to you, Laura.
Well, thank you. Good morning, everyone. I'm Laura Quigley. I'm with Capital Senior Solutions, and we are going to share a screen with our presentation. Hope everyone can see that. I think it looks good. We're really excited to be here today. Let me tell you a little bit about us and who we are. I'm Laura Quigley. Jan Brito is my business partner. Jan, unfortunately, is not here today because she is probably in Santorini at this moment, which I'm very envious of, but she's on a well-deserved vacation. So Jan and I are both licensed realtors. We work in Maryland, Virginia, and DC. And our Capital Senior Solutions division is all about educating and empowering seniors. And we do that through these seminars. You know, our goal is to build long-term relationships with you so that at some point, if you're thinking of downsizing, if you're thinking of moving, that you will be confident and trust us to help you through that process. Jan and I are the only realtors in the local area that are certified senior housing specialists and certified senior downsizing coaches. And those are two different designations. The first one helps with the housing piece. The second one is really all about downsizing. We often get calls from families that think it's time for a family member to move, but it's really not. So we can coach through the process. Let's jump to the next slide and we'll start talking about today's seminar. So today's seminar is the truth about getting your affairs in order. And we call it that because there's a lot of pieces to be planning for in life. And it's not just later in life, it's throughout our lives. So our panelists today, I'm going to jump to this, Jess. Okay, hang on. Where's Megan? She's coming. Okay. For some reason, it's slowly loading. I'm sorry, Megan, we have your photo.
It did this yesterday too. I don't know why.
All right. Well, so these are our panelists today, and they should be tagged on the side of your screen. Antonia Cummings is a family services counselor with Joseph Gowlers and Sons. Alex Lesneff is a financial advisor, and he has just opened his own company, Capital Squared Financial. And we have Megan Campbell, an estate attorney with Willow Legal Group. And let's keep it on this slide for a minute, Jess, because I'm going to have each one of you just kind of tell me about yourselves. You know, a little about your organization, your role, your background, and then, you know, what are the types of services? So why don't we just go top to bottom? Antonio, why don't we have you go first?
Thanks, Laura. So like Laura said, I am a licensed funeral director for Joseph Gowlers Sons in Washington, D.C. and the Nova area. I specifically focused on pre-arrangements for Gowlers. So I help families connect with people like Alex and Megan to be able to put together a holistic plan for their financial elements of their estate, their actual legal estate planning, and then making sure that their final disposition plans are in place, as well as how they're going to be set out in the future.
Yes, so thanks, Laura. Thanks, Antonia. I'm Alex Selesneff. I'm the founder and president of Capital Squared Financial. I've been helping people successfully retire and stay in retirement without running out of money for over 15 years now. And this is what Capital Squared Financial is all about. We work with people who are thinking about retirement, transition into retirement, or in retirement. That is our specialty. We're a fee-only firm. We always serve as a fiduciary when we work with our clients. And what that really means is our only source of revenue is essentially what our clients pay us directly. We don't sell any products, and any type of advice that we provide to our clients, it must be in their best interest. And that really eliminates very, very many potential conflicts of interest. We can help you design a specific investment strategy for your specific circumstances. My background is also on the tax side, so tax minimization is something we really focus on. Want to make sure that you pay as little as possible in taxes. And last but not least, we're very responsive. We always get back to our clients within 24 hours, and that's what they really appreciate about us. And again, really happy to be here as part of this panel.
Thanks, Alex. And Megan?
Yeah, hi everyone. I'm Megan Campbell. I'm an estate planning and elder law attorney with Willow Legal Group. We take a comfortable approach to getting your affairs in order, right? So doing estate planning and knowing what to do can be really overwhelming. There are a lot, as we'll talk today, there's a lot of information and misinformation. So we're here to guide you every step of the way. We often get questions, what's a will, what's a trust, what does my family need? We make it as easy as possible for our clients and view estate planning as the gift that you can give your family, because really those are the people that need it and that are going to use your estate plan when you're gone.
Thanks, Megan. So we can move to the next slide. So we've kind of siloed you, each one of you in your own little areas, but how important is it for you to collaborate with each other when you're making a plan? And Alex, why don't you take this one first?
Absolutely. I mean, it's extremely important for us to collaborate. It's, as far as I'm concerned, it's a team effort to make sure that, again, someone is, successfully stays in retirement, at least the way I see it. Very frequently communicate with the estate planning attorney on the team. And of course, Megan is one of them. Same with Antonia, of course. It's very important to plan for perhaps, the final stages of someone's life. So yes, collaboration is key from our perspective.
So would you guys say it's important that, someone has all of these on their team, all of these different types of roles that communicate with each other?
I think it's important to communicate with this team, with at least each of us at some point, right? And you may communicate with Antonia or work with Antonia, once or twice, where you're back and forth with Alex and I may be more frequent. When you have an estate planning attorney and a financial advisor who work together, it makes your life much easier because you can say, you two make sure my plan works the way I want it to. And then we're able to take that off your plate and ensure that it works how, you've communicated your goals to both of us and we're the ones that can implement those goals.
Okay. Antonia, did you want to add anything?
Yeah, something that happens quite often is when people have a traumatic event occur in their life or a loss of a loved one, then they'll oftentimes just come to a funeral home for emotional reasons and start talking about their final disposition rights and how that's going to be played out because maybe the person that they were planning to play those roles out has passed away prematurely. And so one of the things I'm big about is, like Megan and Alex said, is like having a team and directing people to the right people to have on that team so that those things can be adjusted, because you probably will only talk with me once or twice, but we all have things happen unexpectedly in our lives. Maybe that game plan does have to be edited or rearranged sometimes. So being able to have people that you trust to actually direct you to the right people for each specialty is hugely important, because then you can have that person that really knows what they're talking about for each element of that plan, and have everyone document who those people are on your team so that we're easily able to refer you to the right person when you come with a question. Even if you come to the wrong person first, they know who to go to for you.
Thank you. So the next slide talks about something that comes up very often in today's society and our culture, and that is cybersecurity and fear of your personal information being out there. So, what happens if something goes wrong with somebody's account? What protections do you guys have in place to keep your clients' information secure? You want to go first, Megan? Your turn.
Sure. So all of the platforms that we use that collect clients' personal information, we vet with cybersecurity professionals, and they use some sort of military grade or top of the line cybersecurity platforms. And so we keep that personal information there. And then the practices that the firm takes are to the highest standard to access those platforms.
Thank you. Anyone else want to tackle that?
Oh, yeah. I mean, on my end, from the investment perspective, it's of paramount importance. I'll put it that way. We have 2 systems in place. I mean, it's more than that, but I'll explain as 2 systems. At Capital Squared, we have a state-of-the-art platform called Morningstar Office. And anytime I start working with new clients, that is my immediate recommendation. Before you start sending documents my way, which some people do, they just prefer to do it that way, which I do not recommend, meaning by email. We create a client portal for them. They can create their own login, their own password. They can change it at any time. There's a 2-way security in place, meaning that anytime they log in, if they enter their phone number, they would get a code that they would need to enter, which, by the way, makes it so much more secure. And in terms of our investment platform, which is Schwab Institutional, in some sense it's similar, but it's even more secure. One of the concerns, and I get questions about it quite frequently, it's of course about your private information, but also about cash transfers. That's one of those things. So for cash transfers, we always make sure that we have a so-called money link in place, meaning that if any of the clients requests a cash transfer, it must go to the account on file. It cannot go anywhere else to to the prince in Nigeria or anything like that. So there are a lot of things of that nature that are in place. It's very secure.
Great. Thank you. All right, well, let's start to dive into this. Everyone always talks about having your documents in order. We hear that all the time, right? I've got to have my plan. I have to have my documents in order. But how many people actually know what those documents are, and what do they actually mean, and how do they play out? So I'm going to ask Megan to kind of do a brief overview of these, because we're going to talk more later about how you use these. But just in general, walk us through. And yeah. I'll take the last one, the home repair people, because that impacts me more. But I'll let you walk us through.
Yeah. So the first 2 here, your power of attorney and your healthcare documents, which typically includes an advanced medical directive, a living will, and HIPAA authorization. They're called different things in different jurisdictions. So Maryland calls it an advanced healthcare directive. Some places call it advanced medical directive. You'll see a variety of living will options, like a 5 wishes pamphlet often will qualify or be sufficient for a living will. Those documents are incapacity documents, which means they're used when you can't make decisions on your own. And these documents are important because they keep you in control. They let you choose who gets to make these decisions for you. The next are your beneficiary designations. And these are important because they will show how property passes outside of probate. So when you work with a financial advisor, such as Alex, if you have your 401ks or any retirement plans, often, right, you're asked to name beneficiary designations. You want to ensure that those line up with what your wishes are. So line up with your will or your trust, and talk to, a professional to make sure those have been set up correctly. The next documents are documents that work upon your death. So that would be a revocable living trust or a will. Those documents outline your wishes upon your death. When you pass away, the funeral home often will help you in getting the death certificates, and you'll need those for probate process. You'll also need those to activate the beneficiary designations payable on death designations. So a typical estate plan should have incapacity documents, your financial power of attorney, healthcare powers of attorney, a revocable living trust, maybe, a will, definitely. And then, make sure you review your beneficiary designations with your financial advisors to make sure everything lines up.
I just have a very quick comment here. This is kind of like a good way to jump in pretty quick. So a month ago at this point, I had a meeting with one of my clients, and as Megan suggested, this is something we do at the end of the year. We check the beneficiaries. Now this particular time, and it was, she has 2 children, so it was 50-50. So her IRA account would go to both of her children. What I thought I would include the dollar amounts that each child would actually receive. Interesting enough, my client was very surprised to see the numbers. Essentially, her children, God forbid something happens to her while today, would directly receive more than $1 million each. She was actually not comfortable with that at all, even though there was nothing wrong with the setup. But the suggestion was, well, you know what, maybe you should go back to your estate planning attorney and come up with some other way to actually protect the assets so that they don't go directly to your children who are, somewhat younger at this point. And it's really not clear if they can really manage that much money all at once. So think about it not just from the percentage perspective, but also the dollar amount that your beneficiaries would actually inherit.
That's a good point, Alex. Megan, power of attorney. Oftentimes people get confused about this. When does that end?
On your death.
Right. So we have families that don't realize that. And
yeah. And the effectiveness, so with powers of attorney, the effectiveness is what can be different. You can have a power of attorney that is effective immediately upon signing, which is great. It means your family doesn't have to jump through hoops to be able to use it. Or you can have what we call a springing power of attorney, which only becomes effective when a physician or 2 physicians have certified that you no longer have the capacity to make your own decisions. By doing that, that adds a little bit of protection. But, it's a discussion to have on who you've selected and your comfort level.
Thank you for that. We had just from a personal situation, my own family, my brother, my stepbrother, when his mom passed, my stepmom, he immediately went to the bank to write checks to the family because he had the power of attorney, which was no longer effective. So, you think you understand these things, but you really need to know. I'm just going to talk briefly about the home repair paperwork, and kind of, Alex, this ties into you also, is, many of our clients have lived in their homes a long period of time and made many capital improvements over the years. So when it comes time to sell the home, they're going to have some tax liabilities. So it's really, what we say is, please, start thinking about that stuff now. Get your documents together, any of your capital improvements, so you don't have to pay taxes on that. And then if anything should happen and the home is being sold by your estate, as realtors, that helps us to promote your home and help people understand what condition it's in. So it's always really important to keep that. And Alex, did you want to say something about capital gains? I know we're going to talk about it later, but.
Well, I know we have a separate slide, but very briefly, my suggestion, and I understand it's not appropriate for everyone, but I'll say it anyway, try to keep those records in electronic format. And I know it's very challenging for people to do so. They keep them somewhere in that proverbial shoebox, but then, 10, 20, 30 years down the road, I mean, who knows what's going to happen. So if you have some kind of Excel spreadsheet where you at least keep your largest improvements, I mean, that would be very helpful, again, 10, 15, 20 years down the road. I mean, I have much more to say, Laura, but I know we have a slide dedicated to
We'll get
that.
to there.
Yeah.
And Antonia, did you want to add something?
Yeah, so just to kind of go over a summary of all of these different documents, because they actually all do come into place on the funeral side after a death has occurred, and in ways that people, like you said, Laura, they don't always predict. And like Megan said, power of attorney ends at death. I cannot tell you how many times people come in and say, I'm not the next of kin, but I have power of attorney, so I'm going to be authorizing this person's cremation. And you cannot do that. Power of attorney does end at death, and if you do not have proper designation, or if your medical power of attorney does not have a disposition authorization clause or something like that, then there really is no way to have a friend authorize someone's cremation. And if your next of kin situation is a little complicated and we can't get a hold of them, it can really be an issue, not only just for expense purposes, but making sure that the dignity of the deceased is actually respected. So we've had people left in our care for 6 months at a time, waiting for courts to authorize us to move forward based on a friendship connection versus a next of kinship. Things like the living will, while they are important for laying out your wishes, they don't always guarantee that your wishes will be laid out, because your next of kin ultimately do have the right to decide what your disposition will be. So if burial is important to you, for example, for religious reasons, but your next of kin are not religiously inclined, then they might be more inclined to do cremation for expense reasons. And so there are things you can do to guarantee that those wishes are put in place. But it takes planning, and it takes me confirming that the documents you have are actually laying out those things in a way that will make it possible. Death certificates are necessary to access funds if you don't have somebody already on a trust or on a bank account for immediately accessing them. So if you can't pay for the funeral rights to get death certificates, to be able to get the funds, it's just kind of a constant loop. And so we have families run into these issues a lot. And it can be a problem. Or, for example, if you're putting these documents into a safety deposit box, but you need a death certificate to open the safety deposit box, but you can't pay for the funeral to get the death certificate, and you don't have the correct paperwork because that's also in the safety deposit box. There are just things that are, you have to think about the whole plan from A to Z point and make sure that there aren't any glitches along the way, because it can be an issue. And like Alex was saying, having those things electronically so that we can easily get them, or making sure you know where your original will is versus putting it in a safety deposit box. So talking to everyone about this holistically is very important. And those are just some of the reasons why. So just like to go over that briefly with people.
No, I appreciate that. And if we go to the next slide, I sort of put together, nope, you missed one. Go back up. Sorry. There you go. I put together this slide because it kind of addresses what you're talking about, Antonia,
Oh, perfect.
too. It's like, what documents do I need? And we've gone through that. And then these are questions we hear all the time. Where should they be stored? Do I need originals? Should everyone in my family have copies? And then lastly, which we'll talk about, is why don't I just use an online legal website to do all this? So to your point, very important that not only are they stored safely, as Alex said, try to do things electronically if you can, but your family needs to know where they are and how to access them. And the safety deposit box issue, it's so interesting to me how often that comes up, because people feel very safe and secure because it's in their safety deposit box at the bank, not recognizing that their loved ones may not have access to that if it's not properly titled. So anybody want to jump in on these?
Yeah. So I think we talked about what documents you need, and some on the storage. The only document that you absolutely positively need the original, can't move forward without is your will. The court requires an original will. And so you need to know where that is. Your family members need to know where to access it. And they will have to explain in the probate petition how they found it, how they came upon it. There is an option to file your will with the court, so you can pay to have it kept for safekeeping with the courthouse. You would just take it down. It's $5 to do. The one thing with that, right, is if you move or if you make any changes, you personally have to go down to the court to retrieve that document. So while it might be a safe place and then your family doesn't have to worry about it, it's not, if you move or if you leave, leave the county, leave the state, it's not on everyone's checklist of things to do as they're packing up and trying to move. So it's an option for your original will. On copies, anyone named in your healthcare directives should have a copy of those documents, or be able to access them online. Your financial power of attorney, it depends. We often advise clients to keep those documents close, especially if they are in good health and don't foresee any reason for their named agents to use those documents right away. Have them executed, especially if they're effective immediately, keep them in a safe spot, and then, when needed, share, with those appointed agents that they have that power. It's an added protection to kind of protect your financial assets if you make those powers of attorney effective immediately. And then my last favorite, online websites. There are a lot of options out there these days, right? There's Zoom, there's Will and Trust, there's Mama Bear. I've seen like there's one popping up every couple weeks. And while they seem, like a good option, they're reasonably priced. And they say, we customize, you can go through our checklist. They don't customize to the extent that working with a professional could. So sitting down and we all three of us talk with clients about what are your goals, right? What do you want? If you can't make decisions for yourself, what do you want? How do you want your assets to be passed? Do you want additional asset protection for your loved ones? And it's those details that online forms can't capture. And I've reviewed a legal Zoom will a week or so ago. And while technically correct, it was a mess. We had to probate this estate and administer it. You wouldn't know who got what because he went through the client went through and answered all the questions, but his books and digital assets were going to everybody. It didn't say that they were being divided evenly between everybody. It just said everybody gets my books, everybody gets this. And so administering that would have been really difficult. And there was a lot of unclear options as to what his goals were.
Well, just if you don't mind, I'll add here. I get this question very frequently when I meet with my clients. Well, I haven't updated my will for a while, or I don't have one. Should I go to one of those websites? Well, the way I see it as a fiduciary, I cannot make that recommendation because many of those websites, they're not even run by legal professionals. And the problem is, and I also like to say this, with estate planning documents specifically compared to, let's say, a financial retirement plan, you wouldn't really know how it works up until the actual event happens. That's the problem. So in short, just don't do it. Just don't do it. Go to see a professional. That's one of the best investments you can make, and it can save you so much money, or specifically your estate or those who would be responsible for it.
Yeah, and that's it, right? You might be saving money on the front end making those documents, but in the end, it's your family that is going to have the stress and the mess and have to pay, probably, a lot more, 10 times more, or even greater sums to straighten it out in a time where they want to, remember you and mourn and be with family, not sorting out a giant mess.
Correct. Well, this is a perfect segue into our next slide, which is, let's talk about estate administration. What is that, and what's involved with probate?
Yeah, so we had someone recently describe probate as mysterious, and it's the perfect description of estate administration and the probate process. Because while it's an administration, right, it is technically a very administrative, bureaucratic process. So upon someone's death, you find their original will, you file that, and a probate petition with the local court. Until that time, all bank accounts, everything is frozen. So oftentimes funeral arrangements, unless pre-arrangements have been made or there's some life insurance, may be coming out of families' bank accounts, right? Once the probate petition has been filed, letters of administration are issued. So that gives your named personal representative the ability to then start acting, opening up estate bank accounts, etc. The process itself, again, it takes 12 to 18 months in Maryland. The quickest we've seen is about 8 months, and that's with a very small estate. There is a required 6-month waiting period for creditors. So once you make that filing with the court will make a newspaper filing on your behalf that says, this person has passed away. Here's the name of the personal representative or the attorney. Please, if you have any creditors, if this person owes you any money, reach out. And so there's a 6-month period for creditors to do that. So oftentimes, if your estate's very small or you're very organized, your personal representative is organized, it's just a waiting period. But you're dealing with humans, at the court. And so even, as professionals that do this all the time, we often will get something in mail and say, what is this? Like who made this decision? And it just depends on whose eyes were on the document that day and came back to you. Similarly, every county in Maryland is different. And the probate and the way the orphans courts in each county handle probate can be very different. So to sum it up, it's not a complicated process, but mysterious is probably the best word.
Okay, well, I'm going to jump to the next slide because there's a lot of things on this slide, and we've touched on some of them because these are sort of more terms you hear or things you're like, I'm not sure what they mean by that. So for example, like the trust documents and power of attorney, we've talked about that. Mm-hmm. The next one, ensuring the property is deeded correctly. That's also very important from my perspective, and obviously from your all perspective. I'm just going to use the example recently where a couple put their home in a trust many years ago. They're both the trustees of the trust. One passes away and the other becomes incapacitated. So their children came into town hoping to sell the property so that they could pay for their mother's care in her new condition, and were unable to easily do that because they were not on the trust and their mother was no longer able to make decisions. So what do we do about that, Megan?
Yeah, so part of this, right, is why, estate planning is a set of documents. And, we often talk to people and say, oh, well, I just have a will, or I just have a trust, or I just, I've got powers of attorney, so I'm good. It's really a set of documents that all work together. So in a situation like that, it's important that your trust names successor trustees. And that, perhaps your power of attorney has the ability to amend a trust to name successor trustees. Or especially with older adults, we talk about the need for some additional powers in their power of attorney to plan for situations in which they become incapacitated, but may need long-term care or may need to qualify for government services and Medicaid, and to allow your agent to be able to make those decisions and, you know, work without having to get the court involved. I'm going to jump down to guardianship just because this fits well together. When you don't have a power of attorney, and you don't, or advanced healthcare directives, you haven't named someone who can make decisions in case of your incapacity, your family members are then, you know, have to go and seek guardianship. Guardianship is a court process. And in that, right, is everything. It is more expensive. They have to, you know, hire an attorney, help with the petition. The alleged disabled person, which is the person whom you're seeking guardianship over, is also, it has a court-appointed attorney for them. And guardianship essentially is taking away the rights of that person. So allowing someone else to make their financial decisions and medical and healthcare decisions. So the court takes that very seriously and allows for, you know, there's a hearing. If the alleged disabled person contests the guardianship, there can be a jury trial. So it's a situation that with advanced planning, we can avoid. And you can stay in control as to who makes those decisions. If you don't have those documents in place and your family members have to seek guardianship, one, they've already got a lot going on. Two, you've lost control over who makes those decisions. Oftentimes, right, it is your adult children or an adult child that would step forward and say, you know, mom or dad are incapacitated and I'd like to take care of them or be able to make these decisions for them. But maybe that's not who you want to take decisions. Maybe it's the child that you would never trust with your money, or the child that has completely different healthcare, you know, views than you do that steps forward. The judge doesn't interview, the judge doesn't make their decision that way. They pick the person that looks the best on paper. And so, right, to avoid guardianship, super important to have those powers of attorney and healthcare directives and allow you to remain in control.
I did want to ask Antonia, the designation for final disposition. What does that mean?
So a designation for final disposition can be necessary in a number of situations where maybe you don't have any living next of kin. Your living next of kin won't respect your rights. They don't live in the area or even in the country. Or you just have very specific relationships that would be complicated if you were to involve just one person in authorizing your disposition versus maybe a third party that's not as emotionally invested. So designation is a individual document or a clause in your medical power of attorney or in your will that's specifically designating an individual. It can be a next of kin person, or it can be a friend or just an entity that you're designating as a as like a law firm or other guardianship, and you're designating that person to authorize your disposition rights. It's very necessary if you're planning for cremation because of specific definitions of the deceased person in the United States, given that a deceased person is defined as quasi-property by the state level, the funeral home's custody, and the next of kin. So cremation being irreversible, they take that very seriously, making sure that the person authorizing it has the right to do so. For burial rights, it's still a good idea to have a designation form, especially if you have very specific religious beliefs or you want to ensure that certain things are carried out. Maybe you don't have children or they're not practicing their faith, or you don't have family that lives in the United States or anywhere close by. It just makes things much easier for whoever it is that you intend to authorize your burial or cremation, because they'll actually be given that legal authority to do so. It's a very simple form. If you have the desire to just do the form standing alone, all that needs to be done is you designate someone, they accept the designation, and it's notarized. Or depending on the state you're in, you can do a clause in your will or in your medical power of attorney, but it has to say you're designating someone to authorize your disposition rights, whether that's cremation or burial. So it's something that a lot of people are unaware of, and it's been the cause of a lot of emotional anxiety for families that have come in to see me when they find out that they're not allowed to authorize someone they've been friends with or even partners with for decades, but they don't have any relational ability to actually authorize it.
So with any, like with trustees or personal representatives or, the designation, it doesn't always have to be family, but it has to be clearly identified. Is that correct?
That is correct. So it defaults to your closest next of kin if you do not designate a specific person. And unfortunately, nobody's perfect. No one's family is perfect. The definition of family in itself is imperfect. So we don't always want our next of kin to be the one responsible for those disposition rights. Or maybe you are in a common law marriage as you see it, but it's not recognized where you're at. So making sure that you're authorizing somebody to authorize your disposition that maybe isn't officially your next of kin can be incredibly important, especially to the people you're leaving behind, so that they aren't emotionally overwhelmed more than they already will be at the time of need.
Thank you. And can one of you just briefly tell us, what is a personal representative?
Yeah, so the personal representative is the person named in your will or appointed if they're not named in your will. As Antonia said, there's a list of hierarchy of who gets appointed, and they're the person who goes through the probate process and carries out your last wishes, whether that's what's written in your will or, what the state plan is for you.
And that does not have to be family.
That does not have to be family, as long as you have it documented in your will, right? If you don't document it in your will, the default will be family. It will be a spouse, adult children, grandchildren, siblings.
And I'm so sorry for our participants today. Please put any questions you have in chat. I should have said that much earlier. And we're going to have time at the end to go through your questions, because I know that it's a lot of information coming at you. So please, if you have questions, if not, we'll also at the end open up and people will be able to ask questions. So let's go on to the next slide. And that's, we've sort of already talked about this, talking about putting a property into a trust. Are there any disadvantages to doing that? Reasons they should not?
So one of the most common questions I get is, what's the difference between a will and a trust? Or similarly, I'll get phone calls that say, all my friends have trusts. I think I need one. And it really depends, right? Trust, a revocable living trust, is a way to avoid the probate process. And, as Alex pointed out earlier with his client who had an IRA that would go to children in amounts that the client didn't really want, right? It's sometimes a lot of responsibility to inherit large sums of money, especially if the beneficiaries are younger and may not be financially mature. So using a trust is another way to control distributions, to protect them, to protect, and say maybe $1 million at a young age isn't a great idea, but let's make your inheritance pay out over a 2 or 3 years or 5 or 10, whatever you want, right? You get to make those decisions depending on your goals. So whether a trust or a will makes sense for folks really depends on what their asset profile is and their interest in avoiding probate.
Makes sense. I want to keep going because we want to give Alex plenty of time to talk about the financial plan. So we skipped one, Jess, sorry. Okay, and this is just something that comes up that I like to address about, and we've talked about documentation and how your property should be deeded. One thing that can come up with this demographic, with people who are older, who are thinking we're going to downsize, we're going to move near our kids, we're going to move out of state. Don't move first and then sell your property in Maryland, because Maryland will hit you with an over 8% tax on the sale of your property because you have become a non-Maryland resident selling. So I'm just going to throw it out there. Do not change your permanent address until after you've sold your home. Now we can go to the next slide. Guess we want to get. And then this comes up very often about people who are preparing to age in place. And the thought is, do we have to, if I'm not going to move, I'm just going to age in place, do I need to do anything differently? My thought is no, but I'm going to throw it to the experts.
Yeah, we've talked about all these documents and everything already, and it doesn't really make a difference whether you're going to age in place or you're moving into a CCRC or assisted living or some other long-term care facility. The documents and how you manage them is the same.
Thank you. All right, so let's start talking about finances, Alex.
Switching gears a bit.
Yeah, we can go to the next slide. All right, so what is a comprehensive financial plan from your perspective?
Absolutely, yes. There's different ways of describing it. I like to describe it as a 3-step process. So you assess, you plan, and you implement. That's how I usually describe it. So the assessment stage is when you meet with your client. You can refer to it as introductory meeting or a discovery meeting, whichever one you prefer. That is when you usually discuss someone's goals and objectives. What is it that you're trying to accomplish? What are your values? What would you like to see in the context of your retirement plan in your own words? That's one of the first questions I like to ask. And then usually people will tell you a story of sorts. Usually as part of this step, you would ask for their financial information, of course, your statements, your tax return. We have a list of documents that we would normally request, and that leads to the next step, which is the planning step. Usually takes a week or so to get there. During the planning stage, you would normally talk about someone's net worth or their net worth statement. That's very important. Would normally go over their asset allocation investments. Of course, their retirement plan or retirement projections. It's actually one of the most important parts of anyone's financial plan. And for that, almost always would have at least 2, 3, maybe even 4 scenarios. So there's the benchmark scenario, exactly the way you see it. So if you do essentially nothing, this is what it would look like for you once you retire. If you make a couple of adjustments to your plan, let's say you decide to retire earlier, maybe later, if you decide to save more, what would that look like? Almost always when I work with clients who are already thinking about retirement, we stress test our own assumptions. Meaning, what happens if you retire? And let's see, we don't necessarily have to go back in 2020, in March of 2020, when the markets were down by 31% in 17 calendar days. Exactly how would that impact your cash flow? Exactly how would that impact your overall financial plan? What protection mechanisms do you have in place? And there's a list of things to consider. And then the final stage is the implementation stage. Usually, again, takes anywhere between 7 to 10 days to get to that point. That's when you meet to discuss, again, the actual recommendations. Every so often, we would adjust them if needed. And then, of course, we decide who would be responsible for the implementation. Now, there are 2 issues with the process, and I'll explain it, and I don't mean it in any biased way. Many financial planners, they mostly focus on the first stage. So they would meet with you, they would assess where you are at this point, they would even run a projection for you, but that's usually where it ends. There's not much planning in place. They would give you a number, you can spend $7, $8, or maybe $10,000 in retirement. Here's a model portfolio for you, and that's the end of it. But in terms of, again, making decisions, when to collect your Social Security, as an example, exactly how you're going to draw from your portfolio and in what sequence, that is not discussed. And the second issue, which usually applies to the do-it-yourself investors who seek our assistance to essentially review their plan, well, they get busy. They receive our recommendations, they look at them, they ask questions, but they never implement them. Or in some cases, they implement some of them, but they forget, and it's already the end of the year. So that's one of the concerns I have, again, on the financial planning side, when some people simply don't implement the plan. All 3 steps are important.
Okay.
Next slide, please.
Yeah, let's go to the next slide, Jess.
Yeah, so in terms of the three issues to consider, and again, this is post-retirement, and this is not necessarily in any order, I'll just describe it this way. The first one is actually what we've been talking about in the first part of our panel discussion today. Make sure that you have an estate plan in place. It's amazing how, I'm going to say 8 out of 10 times, and I'm not exaggerating here, when I meet with clients who are thinking about retirement, or they're already in retirement, they don't have an estate plan in place, or they updated their documents maybe 20 years ago. So make sure you have that in place. The second issue, and that's again very common when you get this referred to as generic advice, when people invest too conservatively, and there's that cliche assumption that if someone is essentially older, they just automatically have to invest more conservatively. Now, in many cases, that's true. Perhaps you should be, if you're in your 60s or 70s, perhaps you should be investing more conservatively versus when you were in your 30s or 40s. But how much more conservatively? And the issue here is your longevity risk. Again, back to stress testing our own assumptions. On average, people are expected to live to age 87. So for males, it's 84. For females, it's 89. But what happens if you live to age 95, maybe 100 even? What are the chances that you're going to outlive your own assets? That's important. And then the third issue, and this really applies, let's say, mostly to young retirees, and that's usually, from mid 60s maybe to mid 70s, this group, is when people don't have a clear distribution strategy. So they assume that, prior to their age 73, and for those of you less familiar, that's when you're required to take your required minimum distributions. They simply draw from their brokerage accounts, from their money markets, from their bank accounts. Once they turn 73, they begin to draw from their IRA, 401k, or other tax deferred accounts. Now, in some cases, there's nothing wrong with that approach, but it's a potential missed opportunity. Why is that the case? Well, let's say you're in this, again, artificially low income years. So, you're collecting your Social Security, you're no longer working, you're in a lower tax bracket. You have options here. You can do some Roth conversions. We're not going to go in detail on what that means, but it can be very beneficial in the long run to actually reduce your required minimum distributions. Or you can simply draw from your IRA accounts, or if you have a 401ks, maybe 10, maybe 20,000, so that you stay in the same tax bracket. Again, in the long run, that can save you thousands, sometimes even tens of thousands in taxes if you do it proactively, right? So you have to usually do it on an annual basis. So those are the top three things. In terms of gifting, of course, we are getting closer to the end of the year. That's when people usually start thinking about that. And I'll just give you three, ideas to consider. I'll start with the basics here. If you're thinking about doing many gifts, 5, 10, maybe 15, people or charities, and you're thinking about smaller amounts, let's say $50, up to 100, keep it simple. Gift cash. Keep, notes of your donations or gifts, and that's the end of it. You really don't need to complicate your life. If you're thinking about larger gifts, let's say to your children or maybe grandchildren, consider appreciated stock. Specifically if your children or again grandchildren are in a lower tax bracket, because you transfer it to them, they can keep it, or perhaps they can sell the stock and pay taxes at a much lower rate. And then what I've been working on, and we'll be focusing on that even more, if you're over the age of, again, 73 and you're required to take, again, your RMDs, consider donating a portion of your RMD to charity, if you have that charitable intent, because that would essentially, the portion that you give to charities would bypass your taxes. So you would reduce your income by that amount. That's one of the most powerful strategies to save on taxes for those who are, who want to support different charities.
Alex, this is such great information. I'm sitting here smiling because when you're talking about the aggressive investing and, within my own marriage, there's one of us that would be more aggressive, and there's one that's like, no, we're older. we need to be conservative in our investments. So I appreciate that. I think you're on my side here a little bit, that we need to look at the whole picture, not just, what we think we should be doing at this age. Let's go to the next slide.
Hold on, before we move on, we do have a chat question that mentions stocks. Margaret says, my spouse recently died. We had a joint credit union account. Everything transferred directly to me with very little time or fuss. Our stock account was in his trust and has taken months to get transferred. Wouldn't it have been better if I had been a beneficiary account?
I'll take that one. It depends. It really depends on what the goals were. So, having a joint account, we didn't talk about this with beneficiary designations, but it's an important one. When you have a joint account with another person, that you pass away, that person becomes the sole owner of the account. So often you see that with spouses, but the other time we see it quite often is older adults adding their adult children to their bank accounts. While that may make it easier, right? You don't have to rely on a power of attorney. They have access to your account. Upon your passing, that account becomes solely theirs. Or, if they get divorced, they have an interest in part of that account. So that's part of their kind of divorce proceedings. So while administering and adding a child to a joint account seems easier, it may not work within your goals and estate plan. Similarly, right, naming your trust as a beneficiary of a stock account, it may require a little bit more on the administration, especially depending on who owns that or who the market who has that account. But it depends on what the trust says and what the goals were of your estate planning. Oftentimes we name trusts as the primary beneficiaries of accounts when there is tax planning or marital planning being done within the trust, because that is how you achieve the goals with those plans.
Hopefully that answers your question. If not, please add more to the chat. So Alex, we talked about this a little bit, but when considering liquidating your assets, are there certain things people should think about doing first?
Yeah, so usually the idea, the way I would approach this, what's the most tax efficient way to do that, essentially, to liquidate your assets? And as I mentioned earlier, in some situations, perhaps in many situations, starting with your brokerage or taxable accounts or stock accounts, which is how some people refer to them, is a good idea, because if you sell a stock, let's say it's appreciated by 20%, well, you'll be paying capital gain taxes on the appreciation. And if you held that stock for more than 12 months, meaning in the long term, your tax rate would be anywhere between 15 to 20%, so relatively low. But again, and I'll say this again because this is important, if you find yourself in a lower tax bracket, meaning 10, 12, or maybe even 22, perhaps it would make sense for you to begin drawing from your, again, pre-tax accounts prior to your age 73. In some cases, actually, you can even be in a negative tax situation, so you can draw 20 to 30,000 to essentially offset that. But again, you need to plan for that. In terms of real estate, by the way, usually, at least the way we design the retirement plans for our clients, that's the safety net that you have in place. I mean, we can always talk about how you can potentially use it in the future. Again, back to the scenario analysis: should you sell? Should you do a cash out refi? Perhaps do a reverse mortgage? Should you set it up in a way where perhaps your siblings are covering your expenses? Not siblings, I'm sorry, your children are covering your expenses so that they can inherit the house with a step up in basis, so they don't pay any taxes, essentially. So there are multiple ways of structuring that.
Let's go to the next slide, because we talked about this earlier and you sort of alluded to it here, and that's capital gains.
Yeah.
Could you explain to us a little bit about what that
Absolutely.
is and ways to help with that?
Yeah, so the best way to explain is I usually just start with an example and I'll keep it simple. So let's say you purchased a home for $500,000. Maybe it's a large amount, but we'll just start with that. And let's say the house appreciated to $1 million as of today, as of the date of sale. So if you're single and if you decide to sell the home, you would have a homeowner's exclusion of $250,000. So that would be added to the cost basis of the property. In my example, it would be $500,000. If you're married and if you lived in a house for 2 out of the past 5 years, it would actually be $500,000. So back to my example, you would actually end up paying no taxes at all if you're selling as a married couple and if you own the house jointly. Now, I believe that was one of the questions earlier. If you made improvements or permanent improvements to the house, you can also add those to the basis of the property. Again, that's why it's so important to keep track of them. Sure, if you have that shoebox where you keep the receipts, that's fine, but it's better to do this electronically. Plus the selling costs. That's something that you can also include to the basis, or basically subtract from the capital gains calculation. Now, I will warn everyone who is participating in this call today. Almost every year, right around March or April, someone reaches out to me and they're so surprised when they end up paying capital gains taxes, simply because they never try to essentially estimate what it would look like ahead of time. That happens. Again, the calculation is relatively straightforward. There are some nuances to it if there are any additional questions, but before you sell, please sit down. And yes, you can do it yourself. It's better if you reach out to someone, to a professional, essentially a CPA or financial planner to help you with that. Because again, you don't want to end up in a situation when you spend the money to perhaps buy a different home or you just, invest it, and then comes the tax time and you owe 20, 30, sometimes even 40,000+ in taxes. So please be careful with these calculations.
Okay.
And Laura, can I
Sure.
note other thing that we see often are adults who are adding your adult children to your deed ahead of time to avoid probate and to avoid, having them inherit directly. So their name's on the deed, no big deal. When you do that, you lose a step up in basis, and potentially your children could have a big capital gains issue where if they inherit, the tax calculation is done from the date of your death. And so again, big difference in capital gains calculations.
So Megan, it sounds like some of the advice that you hear, put your kids on the deed, put your kids on the bank accounts, although that seems simple, that there are negative repercussions to doing that. And that's why it's speaking to someone like you and to Alex about what does that impact on your estate? What is the impact on your children financially is really important. And that is a case-by-case basis. It's not something we can generically.
Right. And we've had clients that say, oh yeah, I know, that's fine. I'm not worried. I want to gift, the residents. It also has gift tax implications. So you really do need to work with an estate planning attorney and your financial planner when you're thinking about any of this, and just get educated on what it means. So then you can make a decision that aligns with what you want and what your goals are.
Correct. Thank you. All right. So I think we just have one more slide in terms of these things. And that's the benefits of the, we missed one, Jess, sorry. The homestead exemption, if there's any other tax considerations. Anyone on the call who owns property I'm going to talk about Maryland, there is the homestead tax exemption that you should already be getting. If not, if you don't know what it is, just reach out to me. I can show you quickly how to look at your tax bill to see if you're getting that. It's I think it's around almost $700 a year, which, hey, it helps to do that.
Absolutely, yeah.
Are there any other tax considerations you wanted to mention, Alex?
Well, in terms of the exemption itself, it essentially limits how much you'll pay in taxes. If you get an assessment of like 20%, I believe it's going to limit it to no more than 10. So that really helped actually many people over the past 3 years when the assessments skyrocketed. But you get it automatically. So you don't necessarily apply for it unless you just bought your house. At least that's my understanding, and that's really the only time you need to make sure that it applies to you. But then, in the future years, it will be automatic.
Yeah, in the future years, but there are times when people have not. So it's always just good. In fact, when I was preparing these
Absolutely.
slides, I went and looked at mine just to be like, am I sure I'm getting this? To make sure it happens. So this is sort of our last slide. Our next slide is sort of getting to be the last slide. And that is for each one of you. And I'll start with Antonia because you've been quiet for a little while. What are actions that you recommend people can do like right now? Because this can feel a little overwhelming. You guys are talking about a lot of things. So what would be actions that you would say, like, if you had to make a priority, what should you work on first, Antonia?
Well, I mean, the answer, like you said, is overwhelming, and we're clearly making it, we're showing how important it is really to do all the things. But I think what you can do first is have a conversation with the people in your lives that are important, and with yourself, just kind of internally contemplate what your priorities are. And that will really help you determine where you should start. Depending on age, family situation, financial situation, those might be factors in where you should start. So the best place to start really is just thinking about what it is you want, and then thinking about, well, how am I going to get to those goals, so that you know where to start. Like, for example, if people do come to me first because they want to start with that, I always tell them, well, do you have the necessary paperwork in place to be able to fulfill this? Like, you clearly want cremation, but I'm going to recommend that you go talk to Megan. So thinking about what you want is always going to be the first place, so that if you come to any one of us, we're going to know who to tell you to go to, even if you don't know yourself.
Thank you. Alex, you want to jump in?
Yeah, well, I'm gonna make it very practical. Maybe we'll touch on something else. Purely from the investment perspective, it's been a very interesting year. There's a lot to be said, but I'm not going to do that. Consider harvesting losses in your taxable accounts in November and December of this year, because again, that can help you save thousands in taxes, not just in the current year, but in the future year. I'll just give you an example for one of the accounts. We did it earlier last week, I believe. So the account is actually up in value, and that's what many people misunderstand. So it's up in value since the beginning of the year, but it just happened that only a couple of funds really appreciate in value so much so that the account is up in value overall, but there are many holdings that are in the negative. So that's how you harvest losses, and then you can essentially use them to offset your gains again in the future years, and you can even carry them forward for unlimited number of years. Harvesting losses can be incredibly powerful at the end of the year.
Thank you. Megan.
Yeah, so I'm going to take a little turn here. We spend a lot of the time talking in this presentation about you need to see a professional, right? There's lots of documents, lots of moving parts, and go speak to a financial advisor or estate planning attorney. And so I always like to leave people with something you can do that is a great gift for your family that you don't need any of us to do. And that is capturing some of your memory and your legacy. We talk, in very real terms about money and finances and those pieces, which are important, but what often gets overlooked is those intangible assets that you have, the stories and the memories and the things that you've done with your family that don't get captured in an estate plan. They don't get captured in your financial plan. And so an action item that you can take now is as simple as going through photographs and writing down who's in the picture, what happened, what's the date. Writing a letter to your family. I know Antonia has stories of, really reducing family conflict by having letters that explain, right, how much you love your family, how proud of you they are. Similarly, right, we help clients do a legacy interview and capture those things, because in the end, when you're not here, what your family's going to miss the most is hearing your voice and seeing you and having that little piece of kind of your normal everyday life. So you don't need a professional to do this. It's something that you can do, and the holidays are a great time to even share the stories, get a grandkid or someone to set up their phone as you share stories. So you can capture that and your family will have it forever.
Yeah, just
I think-
to oh, sorry, Laura. Just to go on
Go
what
ahead.
Megan's saying, yes, you may not have a huge estate to leave to the people you care about, or you may have millions of dollars to leave to people and you don't want that to be the main focus when you do pass away. But like Megan said, I've definitely seen situations where the value of just having that thought from the grave, so to speak, of someone that they really loved, how much that can really make a huge difference. And just saying, I'm so proud of you. I'm leaving you this money, or I'm leaving you nothing. But the most important thing to me was everything you've accomplished and how much you meant to me, or whatever. And those things have stopped extreme screaming matches across my arrangement table many times. And it is amazing at what an impact that can be for people.
You know, because when it comes down to it, that's the most important thing out of all of this is, to your point, Megan, leaving our legacy and letting the people that we care about know, you know, what they meant to us. So Jesse, I'm going to have you slip just to the last slide briefly, and then we're going to jump into, you know, questions. I just want to just talk a little bit about this because it kind of ties into what we were just talking about. And that is, Jan and I have a monthly downsizers club on Zoom. And it's for, you could be thinking of downsizing and staying at home. You could be thinking of moving. It could be 6 months, it could be 6 years, but it's sort of a support group where we all get together and people just share resources. Like, I found a place to get rid of books, or, you know, the idea of taking a recording when over Thanksgiving that I'm going to be with my family and I'm going to have the kids interview me. Like, people are just sharing ideas of how to take care of like all our stuff in life. That's not really stuff, like belongings, emotions, everything. So I want to open it up to questions, but I thought, sorry to do this to you, Jesse, if you could go back to the very beginning slide where everybody's contact information is on it. I think it's slide number 4. That way, when we answer questions, you know, everybody could be writing down your contact information if they want to reach out to you all. Sorry. But we probably should have had that at the end. Oh, well, there you go. All right. So we do have chat questions. And let me see. Sorry, let me just. For Alex, is the QCD age the age when RMD are required, or did it stay at 70.5 years old?
So I'm
Can you
happy.
translate that question?
Absolutely, yes. So the QCD stands for Qualified Charitable Distributions, and that's what I meant by saying donating a portion of your RMD. This is very important, directly to charity, because there is still some confusion there when people receive the payments and then they want to donate the proceeds. That's not how it works. It needs to go directly to the charity, and your you know, your brokerage should be able to set it up for you. And RMD again stands for the required minimum distribution age, and as part of the Secure Act 1.0 and then 2.0, it's currently at 73. So you know, 73, you're required to take your RMDs. But the answer to that question, which is actually interesting, I'm not sure exactly why it happened that way, but you're allowed to donate to charities a portion of your RMD. Again, you're allowed to take the QCD approach at 7.5. In practice, it just doesn't make that much sense. It really doesn't, because the idea is to reduce your taxable income. But if you're not required to take any funds out for the next 2 to 3 years, why would you want to do so? If you want to simply donate some of your funds, consider appreciated stock. That can actually be more beneficial for you because you also save on the capital gain taxes.
Okay. Another question. Suppose deceased husband has all assets in joint banking account with wife, and she is beneficiary of his IRAs. House is in her revocable trust. At his death, she needs as his personal representative to file 706 to do portability of his estate tax exemption to her. Can she avoid accounting? How simple can administration be?
Yeah, so that's probably as simple as you can get, right? And there is, if you do need to elect portability and make the tax filings, there's not much we can do to get around that. But with the joint accounts and the home in a trust, that is as straightforward as you can get.
This sounds like this is a well thought out plan.
Yeah.
Okay.
Just on its face.
Okay. All right. Another question. My elder law attorney has done my will and plan for finances to establish an estate and go through probate. My financial advisor thinks I should do TOD on my investment account. This is troubling me. My goal is for my 3 grandchildren to inherit a smaller portion each and my 2 children to split the rest of the account. What should I do? Can a financial advisor split things up that way? Only my name is on the account.
So, and Alex, correct me if I'm wrong, a financial advisor could make those designations. The thing that we need to be careful on, how old are your grandchildren, right? And if they are minors, they couldn't inherit on a transfer on death beneficiary designation. It would then need to go into the court and be put into a trust to have that money managed for them.
Yeah, so this is again, I appreciate you saying that, Megan, and I read that question when we're still presenting. This is where, in some sense, understanding more would be really helpful. So I had a situation, I had a complaint, in fact, from one of the clients earlier. We talked about a TOD account, but we set it up for them. TOD is, again, transfer on death, or POD, paid on death. It means the same thing. But we set it up as a brokerage account, and I suggested that she actually talks with an estate planning attorney first. Because the issue here is that, again, the funds would go directly to the beneficiary. And is that truly what you want? And in your case, Wendy, I'm not sure. Again, so yeah, this is where I would say knowing more about your situation would be helpful.
And people can, from this seminar, your contact information is here. They can reach out to you directly.
Absolutely.
And to lay things
Yeah,
out.
but see, again, the point I'm trying to make, I was trying to be very careful in terms of how I say it. As a financial advisor, I believe it's my job to inform my clients of what options they have. They can just keep it in a brokerage account. They can set up a revocable trust. They can title it as a TOD/POD, and I can talk about different pros and cons. I do not believe I'm in the position to provide specific advice of what works best for them. So that's why when it says my financial advisor thinks I should do TOD on my investment account, that's a strong position, because that can impact things quite a bit. So
okay. Well, I want to say thank you. There's more questions, and if anybody has to drop off, I hope they don't, but this is such a great audience today, because these are really thoughtful, in-depth questions. So here's another one. Suppose a child is a physician and you want to transfer the house to her without gift tax and in a way to give her high basis in the house. Can she pay a little cash but provide in-kind compensation to parents by owing parents a lifetime of medical care and a place to live? To me, that sounds pretty creative, but I don't know if it's legit or if you can.
So it really, I think we need to talk more and understand your goals and your position and her goals and her position. We can, I think it's true for all of us, right? Based on what your goals, we can usually find a plan to carry out those goals. But it requires a lot more discussion and detail and understanding for specific situations than we can get into on a webinar like this.
Okay. Another question. I've got 2 more questions. How has the 10-year full distribution requirement for inherited IRAs altered thinking about estate planning?
Yeah.
So that's a great question. And in the estate planning field, we are constantly playing catch up here with the Secure Act and those regulations. Congress comes out with Secure Act, with 1.0, we're now on 2.0. When Secure Act 2.0 came out, we were just understanding how the IRS was going to interpret Secure Act and apply the rules. So it has altered in how we plan some, but it's constantly changing, and we're constantly monitoring and advising clients and reaching out, right? If something big has changed and we know clients might need to reconsider how their estate planning works, we would proactively do that.
Well, so I'm gonna make a comment here, and again, Megan, of course, that's your area of expertise. So I can just make a specific example. So that was under the original Secure Act that made a very significant difference for one of my clients. So very conveniently, it just happens that she has more or less the same amount in her IRA or rollover IRA and her trust account. Think of it as a brokerage account. So prior to the original Secure Act, the idea was that her charities, and she has very significant charitable intent, would receive her taxable funds essentially, and then her children, she has 2 children, would receive her IRA funds and then stretch the distributions over their lifetime. And I would say that was one of the most common ways of doing this. Post Secure Act 1.0, it's now in reverse. Why? Because the charities, they don't care what kind of assets they're going to receive. They're just going to cash out and use it for their needs. The children in this case are in a higher tax bracket. They're doing really well on their own. So for them to receive the taxable accounts with 100% step up turned out to be much more beneficial than receiving the IRA account and then essentially taking distributions over the next 10 years. I mean, we actually did the calculation. It was very interesting. It was one of the first calculations I've ever done for that type of setup. Again, I am not saying this is going to apply to everyone. All I'm saying is that was a pretty big deal. I mean, for many clients, it made a very significant difference in terms of their thinking of who should be receiving and what kind of accounts.
And Alex, there's one more question here, and it sort of tags right along with what you just said. It says, an adult child gets an inherited IRA from parent under the 10-year rule. Must the child take the distributions in years 1 through 9? What if it isn't a Roth IRA? And what if the parent was below RMD age?
So there are 3 questions here. I'll address the second and the third first. Okay. So it doesn't matter if it's a traditional Roth IRA, the same rules apply. The age of the parent also does not matter any longer. So the child would need to take the funds out over the 10-year period. As we speak today, and the last time I checked was maybe 2-3 weeks ago. I will double check again after this webinar. There's no clarity on the rules. So when the rules first came out, the assumption that I would say that most financial planners made, including myself, is that perhaps it's advantageous for you to wait all the way to year 10 and then take the funds out. But then there were some proposals coming from IRS, I do not believe they're in the final form, saying that you do need to take some funds out in the first 9 years essentially and pay some taxes. That wouldn't really apply to the Roth IRA, of course, because it's tax-free. So the way I've been essentially saying this in terms of those of my clients who are in this situation, if they need some money, and again, they find themselves in a lower tax bracket, well, it wouldn't hurt to take some funds out. But as we speak today, and Max, feel free to email me and I would be happy to look it up for you. I believe there's still no clarity on the actual rules. Megan, correct me if I'm wrong on that.
No, not yet.
Okay, so we've come to the end of our time, and I so appreciate all of you for being here. And I just thought it was really excellent today, the content and all the questions. Is there any last comments each one of you would like to make before we sign off? Antonio, I'd let you go first because you're the top of my screen. So
Thanks, Laura. No, thank you so much for having me as usual. It's always great to hear what everyone has to say. I always feel like I learned something new that I can take back to families that I meet with. And I'm always happy to answer any questions, regardless of whether you're using Joseph Goller Sons for pre-planning or at the time of need. I have personal planning guides or any kind of materials that might be helpful to you, or questions about military burial benefits. I'm always happy to answer those questions.
thank you. Alex, any last comments?
Well, same again. I very much appreciate everyone joining us today. I certainly felt like a productive session. If there are any questions that any of the participants have, please reach out to me. One thing I like to say for new clients, specifically, or those who are interested, we offer strategy sessions, and these are complimentary. And essentially, if you have questions and if you're willing to provide some information at least ahead of time, we would make sure that it's productive. So it's not just let's get to know each other and that's the end of it, but really want to make sure that you walk away with at least a couple of nuggets of information. So again, thanks everyone for joining us today.
Thank you, Alex. And Megan.
Yeah, thank you, everyone. This is always so much fun, and we get some of the best questions from these panels. So I really enjoy doing it. I dropped in the chat a checklist if you are interested in looking at your documents and seeing where in your estate plan you might need to talk with your estate planning attorney or professional. It's a free checklist to download and walk through. And then similar to Alex, we offer complimentary discovery calls to talk about where you are and what you need. And you can access and book those directly from our website.
Thank you. And lastly, Angelique, do you want to?
I just want to say thank you to our panelists. I truly appreciate your time and expertise. Thank you, Laura. Great partnership in hosting these educational events. And I hope that everybody enjoyed and learned as much as I did.
Well, thank you. Yes. So thanks, everybody. And hopefully we will see all of you on a future event.
Yes, we do have an upcoming event, December 13th. It will be virtual as well, and we're going to explore the continuum of retirement communities. Have a great day, everyone.
Thank you. Bye-bye.
Thank you very much.